All right, let's get started. Welcome to the Micklin Law Group's, I guess it's more of a bi-monthly webinar series. My name is Brad Micklin. For those that haven't worked with me, this is me. I'm the lead attorney, managing member of the Micklin Law Group, a law firm concentrated in men's and fathers' rights in divorce, custody, and family law matters, with offices in Nutley, Montclair, and Saddlebrook, New Jersey. The QR code on the screen should be what takes you to my meeting calendar. If you want a consultation with me, or if you're a client or a past client and want to schedule a meeting with me, you can snap that QR code now or just save it in your photo album in case you need it in the future. For new clients, you will be requested to call and fill out an intake just so we can make sure that there are no conflicts and that we're a good fit for your case. For those that haven't worked with me or those that will work with me in the future, here are some client and peer accolades that I've been honored to receive over the years. I put these here not to try to impress people, but to impress upon you the experience that I hope I bring to not only these webinars, but the work that I do for you. I've also served as a national legal consultant. I've been on Fox News, Larry King, Inside Edition, various other sources. Again, not to impress, but to show you the wealth of coverage that I have had, the experience that I bring to the work that I do, as well as my enjoyment of it. Hopefully that shows through everything that I've done up to this point. Securing custody in a changing legal landscape. What dads need to know. As I indicated, the Micklin Law Group is concentrated in men's and fathers' rights. It's been our focus for many decades. In today's evolving legal environment, fathers seeking custody in New Jersey face unique challenges and opportunities. This presentation explores the shifting judicial approach to fathers' rights and provides practical strategies to navigate the custody process successfully. All right, let's start with the new reality for fathers in New Jersey custody cases. The landscape of custody cases in New Jersey has transformed significantly over recent years, creating new opportunities for fathers. Our law is explicitly gender neutral, which grants fathers equal legal rights in custody determinations. Courts are now supposed to prioritize maintaining relationships with both parents equally, whereas historically the maternal preference was the guiding source and it would diminish fathers' roles. Now, the laws have come a long way. Historically, when I started practicing in 1996, fathers basically were presumed to be visiting. And that's actually what we even called it, visitation. You never had equal time. No, I shouldn't say never. Very rarely was there equal time. Almost never was there sole or primary custody. And again, we called it visitation. Jump ahead to 2025, which is when this is being recorded, by the way, August 15th, 2025 in New Jersey. So it is, albeit New Jersey-based law, but more of a practical, pragmatic approach. There's not a lot of law, but it still will be more or less jurisdiction specific. If you are outside New Jersey, obviously you want to consult somebody recent or more local to you. But in 2025, there's been a huge shift, partly because there is a belief in our legislature now that both parents should have as much time with the children as possible. Now, unfortunately, what was proposed was a statute that said that they're presumed to get equal time. That was defeated, unfortunately, and I think that speaks volumes to where we still need to go with this issue. But it was replaced with a statute that says parents should get as much time as possible. So that can open the argument where a father may have more than equal time, depending on work schedule, availability, whether they're working from home, and the child or children's schedules. So we try to use the statute that was unfortunately not so progressive, but we can still find ways to use it to your advantage. So let's look at how courts decide custody beyond gender to caregiving roles. One is the primary caregiver analysis. Courts will evaluate which parent has historically handled day-to-day responsibilities such as feeding, bathing, arranging medical care, and managing school activities. This can be challenging in today's environment. We have a significant number of families where we have both parents working, which is helpful. But in my practice, which again is in northern New Jersey and central New Jersey, I still see a lot of traditional families where one parent, typically the father or husband, is working and the mother is a stay-at-home spouse raising the children. Whether or not the children are, needing a constant caregiving or in school all day, there's still many that are home and not working. If you were a primary caregiver, an equal caregiver, or even substantially involved, you want to make sure to have records of that, and we'll get to that a little more later also. That having documents and information touches on many different issues about custody, but when it comes to primary caregiver, the information that's going to be most important is going to be their doctors, their ailments, their special needs or skills, their challenges, educational, mental, psychological, medical, their friends, their teachers, their activities, their extracurricular, things like that. 2, stability assessment. Judges prefer to maintain existing arrangements that provide consistency for children, including home environment, school, and community connections. Now, this is the area where it more often hurts fathers because, as I mentioned, in my client base being more often traditional, dad is working, mom is primary caregiver. Judges use that as an excuse to call what we say the status quo for the child and keep mom as a primary caregiver. Our argument always is first that dads were always there, whether it's less than equal time or at different times, at nights and holidays, weekends, when mom was unavailable or unable. But more often, also the status quo has changed. The status quo always changes. Dad may have been able to protect the children from mom's lack of stability because he was there. And now that he's not going to be there, the status quo is not going to be in the child's best interest. But it's important to be able to enunciate this change and show it with information and documentation. Lastly, is shared custody considerations. New Jersey courts increasingly favor arrangements where children spend substantial times with both parents, as I mentioned, acknowledging the value of maintaining strong relationships with both mothers and fathers. Again, this doesn't mean equal time, but it doesn't have to mean less than equal time either. It can mean more. I try to counsel my clients to stay away from counting days and percentages, and it's not about 50% or 60%, but try to maximize the times that you have and that will be meaningful. Having 2 months in the summer, for instance, may be a lot more than having an alternating weekend schedule, or even having a weekend, week off if you're going to be working all day. But you have to look at your individual commitments and to figure out what's best for you and your children. Additionally, while these are important and primary factors, there are several more that the courts will look at. I won't go into them at all. Most of them are not as significant, and many of them are not even relevant, but they are things the court's supposed to look at, like past domestic violence, relationships with other children, maybe other families like step parents and step siblings that are involved, educational needs, things like that. So there's a lot of things that go into custody determinations that are a little bit broader than the point of today's webinar. Types of custody: legal versus physical. Let me see if I get the slide a little better slot for you there. So here we're trying to show the overlap. Understanding these distinctions is crucial for fathers developing custody strategies. New Jersey courts favor joint custody arrangements that encourage cooperative decision-making, even when physical custody may be awarded to one parent. So first, before we go into the types of custodies, I always tell my clients, don't use custody terms because we have many. Here you're looking at legal and physical. There's also residential. There's also joint and physical. So you can have joint legal custody and sole physical custody, or primary residential custody, and it can get confusing. And I counsel clients against using the terms because sometimes you'll ask for a type of custody that really isn't what you're looking for, and you'll ask for the wrong thing, you'll present the wrong idea, and it may actually harm or hurt you getting what you were looking for, and you might have been able to get it had you packaged it correctly. That being said, when you talk about joint and legal or joint and physical, joint and sole, legal and physical, legal custody is making important decisions: medical, educational, religious, residential. Physical is where the child stays or sleeps. Now, generally speaking, New Jersey almost mandates that these be joint legal, joint physical. But it's important to understand that joint doesn't mean equal, which is why we don't say equal, we say joint. So having joint legal custody does mean more of an equal say in important decisions, but the courts will still defer to the primary custodial parent's concerns or considerations when making day-to-day decisions. If there's a conflict, even when making important decisions and there's a conflict, they will more often than defer to the person where the child stays more often, because that person is usually the one charged with the day-to-day maintenance of whatever this decision may be. For instance, you're arguing over what school the child should go to. Well, if the child lives with, let's just say mom, to make this easy as we go through the webinar, if the child lives with mom and dad lives 40 minutes away, or their schedule is moms have the child Monday to Friday, and mom's taking the child to school. So where mom wants the child to go to school is more likely going to be where the court rules the child should go. That does not mean you can't argue that the child should be better served or would be better served at a different school. That can also be a reason to change custody, to have the child who was with mom Monday to Friday with dad, so he or she could go to the better school. But it's important to understand that even when you have joint legal custody, that doesn't mean you're going to have equal say in the decisions. If you're making an agreement for custody, you might want to spell out how decisions are going to be made with regard to the issues such as medical, educational, residential, religion, so that you will ensure a process to guarantee you have equal say. Now, physical custody also, that's where, like I said, the child sleeps. That can be joint but not equal. You could have one overnight in a year and you still are considered a joint physical custody. So it's important when you're trying to consider whether or not you need an actual schedule in place. You know, some parents like to keep it loose and they have cooperation and they say we're sharing equal and we just switch the children as we see fit and we change the schedule as we need to. More often than not, that doesn't work, even with the best intentions, because conflicts come up. I generally think it's always good to have a schedule in place, even if you're not going to follow it, because when there's a conflict or a breakdown, you know what to go back to. Overcoming common challenges fathers face. Persistent bias. Generally, or despite equality, some societal and individual biases remain. These are diminished through increased awareness and legal advocacy for fathers' rights with firms such as mine. And there are some others, but not many. This is important. Obviously, primarily we're speaking about judicial bias, judges' bias. Fortunately, that is taking a significant term, largely because the judges that were practicing 20 years ago when I started, 25 years ago, have often retired or are retiring. New judges are coming up, and they were coming through the practice at a time where we had a greater recognition for a father's equal rights to parenting. But also, there's a bias with mothers who often treat the children like it's their property and that they have the right to make these decisions. And the father, in many cases, they feel doesn't have the right to equal time or to equal participation. They believe as a mother, they are better equipped, they are better capable, and that the fathers are less entitled. I'm not going to get into my soapbox about that, but it is something you need to recognize when you're going into some custody challenges. Emotional hurdles, stress, anxiety, and knowledge gaps can undermine your case. Preparation and emotional support are essential to maintain your focus during these types of proceedings. That is more important than a lot of people recognize. It is unbelievably difficult to go through a custody case, especially if it's coupled in a divorce. As a divorce attorney, I've seen for decades what people go through. I got divorced myself, so I got to sit on the other side of the table. And many people are not ready for how difficult it's going to be when everything about your life is being ripped in pieces. Everything is under a microscope. Your custody arrangements, your housing arrangements, your finances, your credit cards, your home, all changing all at once. And if you have a lawyer, it's often an expensive process. So you're spending a lot of money. It's an unknown process and everything is changing. That can be, for the strongest of people, impossible to handle all at one time. I always urge my clients to seek professional counseling, therapy of some kind, support groups, anything that will help you get through this. And false allegations, accusations of abuse or neglect, which will require immediate strategic responses. Documentation and legal defense are crucial to protect your relationships with your children and yourself. False allegations, and there's more to come in a later slide or two, but this is a common approach and a successful one, because in intimate relationships, there usually aren't witnesses. You're not often recording your on the couch conversations. You don't always keep your text messages. And unfortunately, people still lose their temper in recorded messages like voicemails or text messages. And it often comes back and allows the other party to pervert that message into something more harmful. So recognizing these challenges is the first step toward developing effective strategies to overcome them. Proper preparation will allow you to successfully navigate this process. So what happens when false allegations arise? And we've been talking about this just in piecemeal throughout, but first, stay calm. People fly off the handle and they will often send messages, take action, contact persons, send a message, and it can only be possibly more harmful. What you want to do first is document evidence. Take your emails, take your text messages, take out your calendar, start writing down notes. If you record something that you write down yourself, you might be able to use that later as a recorded recollection. Go through your bank records, go through your credit card statements, gather everything you can. Who knows what more might be coming. Next, get legal help. I don't say that because I'm a lawyer. I say that because when I was getting a divorce, I got a lawyer. That's what you do. Even if it's just for advice, just to make sure that you understand what you're facing, just so you understand what you need to do next. Next, you might want to request evaluations. If it's a custody, you might want to get a psychological evaluation of each party, possibly the child. You might want to get a custody evaluation to determine what's best for the children. Mental health issues, you might need a forensic analysis of finances for child support. Could be countless reasons you might need an evaluation, which is why getting legal help will help guide you into that domain also. And maintain boundaries. Don't overreact. Don't reach out. Don't try to solicit support immediately to defend yourself until you understand what you're facing and where you're going. And a critical warning, don't make counter allegations without evidence. A false claim can severely damage your credibility and result in sanctions or possibly even a loss of the custody rights you're fighting for. We'll get a little more into that in this slide. Other risks to consider and prepare for. The number one, temporary restraining orders. Be prepared to respond appropriately as served with the TRO. Have a legal response strategy ready and understand the implications for your custody case. Follow the court orders meticulously when going through this. This is crucial. This is the most common weapon I see. It's supposed to be a protection. I would say they use it as a sword, not a shield. It is very easy to get a temporary restraining order against somebody. Not so easy to get a final, but a temporary, which will take you away from your home, from your children, may bar you from having parenting time, and it may be for a very long time, despite what the statute says about 7 days for a trial. First thing to do is read the restraining order. It will tell you if you can even have contact with your children. It will tell you if you're barred from having contact with other people, like a boss or an in-law. It will tell you where you can or where you can't go, like a workplace or an address. You want to make sure before you reach out and say things like, why did you do this to me? Or call the kid and say, I'm sorry, I can't make it this weekend, because you could be violating the order, and that's criminal. Now, while my previous slide had a critical warning about false allegations, which I wholeheartedly meant, you do want to consider a counter complaint or a cross complaint when served with a restraining order if you have been the victim of domestic violence in the near recent past. Quite often, when one alleges that there's been domestic violence, there's been a challenging interaction or relationship that will often not be simply one-sided. Now, I'm not saying that you run out and file a cross complaint. I take a lot of time to counsel my clients on this issue. On the one hand, it's helpful because it balances the playing field. It puts them a little on the defensive. It also causes them to incur more costs and stress and time. However, it will always look retaliatory right on its face because you did it after being served and not before. Nonetheless, it doesn't mean it's invalid or that it's unsuccessful or that it's ill-advised. It's just got to be something carefully considered before moving forward to do so. Children's preference claims. Second, understand how New Jersey evaluates their preferences based on age and maturity. Be ready to demonstrate strong relationships regardless of temporary preferences that may be influenced by various factors. This is a challenging area. Children will often, in a high conflict acrimonious relationship, indicate a preference to be with one parent. More often than not, the custodial parent, the mother. That can be because mom has been saying to the child, I want you to say this. But it can also be the child observes this, senses this from the custodial parent, from mom. And because the child needs to survive because he or she's living with mom or because he or she may want to keep mom happy and please mom, they're going to naturally sense that they should not want to be with dad. They often pick up that it hurts mom, for instance. So they may be saying they don't want to go with dad, not because they don't want to go with dad and not because mom has been telling them to do that, but because of the dynamics of the situation can be influencing their preference. Address that right on head first, because if that's the case, along with alienation, which we'll talk about in a second, sometimes you want to go for a very aggressive approach like a change of custody or an increase in parenting time. Along these lines, again, parental alienation concerns, research alienation signs so you can see them when they start, document, and look at treatment options. Notice how to identify the patterns that may indicate alienation and look at how the courts respond to them. The reason you want to do this quickly is because alienation is effective, but it usually takes some time. Unfortunately, the court process is very slow, so they often get the time. So you want to act as soon as you see alienation occurring. And again, research the solutions. There are some programs out there I often am advocating for the courts to adopt where the solution is advocated that the child should be removed from the parent who is seeking to alienate and sometimes entirely and placed with the other parent. In my opinion, that is the only way to undo alienation concerns is to remove the child. But that runs contrary to the courts favoring the status quo and maintaining the best interests of the children. So you have to argue why it's not in the child's best interest. And remember what I said, courts are very slow in all aspects, but especially in these kinds of aspects. So you need to be prepared ASAP if you believe or see any of the signs of alienation. And the first step is learning what they are. Proven strategies to strengthen your custody case. As I've been saying probably in every slide, document your involvement. Keep detailed records of participation in their lives, school meetings, doctor's appointments, extracurricular activities, daily care routines. Save emails, texts, photos, and a calendar of everything that you've done with your child. This can be in any form. It can be a Google Calendar. It can be PDFs. It can be notes on a pad. You're going to want to show that your involvement, your equal involvement, is part of the status quo. Second, develop a comprehensive parenting plan. Create, hopefully with an attorney, a detailed child-centered proposal addressing schedules, holidays, education, healthcare, and communication methods. Show that you've considered the child's needs specifically. Here's what's important. And I try to indicate this to all my clients, and I argue it often in court because judges don't often realize this. The standard of all child-related issues in New Jersey comes down to the best interest of the child. And inside of that sentence that people just throw around like it's a colloquialism are two very important facts. It's best interest, so it's not good or better, and it's for the child, not for the mother, not for the father, not because it's favored or approved by a doctor. It's got to be what is absolutely best for the child. So a lot of times you'll hear, for instance, you'll be opposing an argument where mom wants to relocate, and the argument always falls down to, I'll get a better job, I'll have more family support. That's all great, but that's really all for the mother. That's not to the child's interest necessarily. And that doesn't necessarily mean, even if all that's true, that it's best for the child when you're looking at taking the child away from dad. So you really want to remember and keep focused on those two aspects and keep bringing the judge back to the fact that whatever's being argued, if it's against your interest, is whether or not it's best, not good or better, and for the child, not for mom, not for grandmom, not even for you, but for the child. Lastly, although this may sound a little different from what I've been kind of advocating, is demonstrate cooperative co-parenting. Maintain respectful communications, avoid criticism, especially in front of the child or on social media or in text messages or emails, because it's in writing and it can be reproduced. Courts favor a willingness to co-parent. Now, I know I've been coming from a position quite often of be ready to fight this, you're going to have these allegations, you're going to be cut out of this part. And I come from a position of acrimony and litigation. That's my background. That's the work that I do. If you didn't have that, you wouldn't necessarily be coming to me. If you had a cooperative co-parent arrangement, you wouldn't even need this webinar in the first place. So if you have it, great. You can turn it off. But the point is, you want to come from this position. You want to, even if it's just your vocabulary or if it's your proposal to the court, always make it appear and be that it's going to be cooperative, co-parenting. That has got to be the intention. Legal tools and support systems available. And this obviously is a general slide, and there's many others available. Paternity establishment. For unmarried fathers, legally establishing paternity through the acknowledgement forms or genetic testing is essential to asserting your custody rights. More often than not, in an unmarried couple's first court appearance on custody or child support issues, the court will order a paternity test, even if the child is, well upon advanced aging, 5, 10, 12. If there never has been a paternity, they will seek to have one because they want to have stability and consistency in the child's life from a financial standpoint for things like child support, college contribution. So paternity is significant. If you are able or willing to acknowledge paternity, they would usually take that, I think, over ordering a test. But I've even had some judges, even with the acknowledgement, order the test because it eliminates challenges in the future. Specialized legal representation. Work with attorneys experienced specifically in father's rights cases that understand the challenges you'll face in court. Again, I don't say that because it's what I do. I do that because it's what I believe. If you go to a general practice attorney, no offense to them, it's a skill that I didn't have. I couldn't stay up on everything back when I opened my practice, so I concentrated. But a general practice won't be well-versed in the issues you might deal with. They might be well-versed in custody matters and the law, but they're not going to have the insight that somebody who's concentrated in these areas have. As amends in father's rights, and there are many others that do this, not just me, we further understand the issues that you're going to face as things develop, not only in your case, but in your future. Things that you don't often contemplate, like religious activities that are coming up, or when there's a new partner involved in your life or your spouse, your other partner's, your other parent's life, how that's going to impact the custody and the acrimony levels. That doesn't happen without having experienced a great deal of cases like this, or like yours. Court services and evaluations. Utilize court-appointed evaluators, guardian ad litems, and custody experts to provide unbiased assessments of your capabilities and home environments. Another very popular tool can be parenting coordinators. That's usually more something you have to elect on your own, and it's an out-of-court process. They're good for people that will have decisions that are needed to be made, enough difficulty between them where they don't think they'll do it themselves, but enough sense where they don't want to have to bring everything to the court. Parenting coordinator is a person that sits in the middle of the two parents as sort of a referee and usually has the power to make decisions that are binding outside of court. And those decisions can always be challenged by the unhappy parent, but at least you get something to work off of. You get a binding decision, which may not be challenged. I mean, some people understand, they take their lumps and they move on. But even if it is challenged, you have an understanding of your rights until it gets to court, and you have some insight of what the court's likely to do. Because if an independent parenting coordinator, who's usually going to be a well-versed, experienced family law attorney, makes this decision, judges will more often than not adopt that decision because of its lack of bias and its experience-based decisions, where parents are usually more emotional-based. Some are, have selfish motivations as to what they're looking to accomplish. PC, doesn't have a pony in that race. So more often than not, the decision is going to be binding. But another reason why you want to work with court-appointed evaluators, it's good to have a court-appointed evaluator in the beginning because the court rules allow, or the law allows, that if you have a joint evaluation and you're not happy with the evaluation, you are allowed to get your own evaluation. If you go with your own evaluator right off the bat and you get a bad recommendation from that person, let's say, or less than favorable, you're bound with that. And most evaluators aren't going to, and most good evaluators, they're not going to make evaluations just because you're their client. So they're going to be objective, independent to some extent. So let them come from a joint perspective, because at least when you take that, you can go to your own expert and say, well, these are the reasons that the recommendation is faulty, or the reasons I can't support it. And you'll get a better rebuttal report or a better independent expert than possibly if you had gone on your own and didn't have that sort of filter to give to him or her when reviewing your case. Empowering fathers, your path forward. 1, know your rights. As I've been saying probably every slide, while you have equal standing in New Jersey, you have general neutral statutes that provide foundation for asserting your rights effectively, but you have to know what they are. You have to know what the law says. You have to have an idea of what the statutes say so that you can argue effectively inside of that parameter. Be proactive. Build your case through consistent involvement with your child, constant documentation, and when possible, and as often as possible, co-parenting. Create a detailed plan that demonstrates your commitment to all of these aspects. And I know I sound like a broken record, seek expert guidance. Partner with legal counsel, experienced in father's rights, to help you navigate the complexity of family court. Also use that attorney to give you experts, custody experts, psychological experts, forensic experts. When we say expert guidance, it's not just lawyers, but lawyers can give you the other parties and players that you'll need to advance your rights and protect your children. The ultimate goal is to create a stable, loving environment where your child thrives through meaningful involvement with both of you. You need to take the action to make sure that you secure a meaningful role in your child's life. As with everybody, we're on social media. You can find us on YouTube. I don't know if you can actually copy this link here, but if you just search my name, Brad Michael Micklin, you'll get me on YouTube. I have webinars of all lengths and all topics that I've been putting up for many, many, many years, all different lengths. I try to be both practical and pragmatic as well as legal. So I'll tell you what the law says and I'll tell you how it plays out. I'm very proud of the YouTube videos that I have up there because I've found over the years that clients come, they don't even know what to ask. So I give you these free resources to get educated before you even talk to an attorney. And they're obviously free. You'll learn what you need to know, what to expect, and you'll be better positioned to ask better questions of where you need to go. We're also on Facebook, Micklin Law Group. I'm on LinkedIn. I don't believe we're on Twitter. And if we are, I don't look or respond to it, so I wouldn't bother. There's also the Micklin Law Group, which I think is on my next slide, which will have a lot of information also. MicklinLawGroup.com. YouTube videos are more robust and easier to search, but there's also a great deal of them. My website has fewer sources, and it's a little easier to navigate if you know exactly what you're looking for. So I'd start with the website And if you don't see exactly what you're looking for, even if you do get some good information from there and blogs, then go to my YouTube for the videos. And of course, you can always call 973-562-0100. Last and least, the legal disclaimer. I'm not going to read this. I'll summarize it. Basically, it's just saying this is not something you can rely on. It is advertising. It is not legal advice. It doesn't create a legal relationship, blah, 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 blah. It is important to understand this, so take a second to read it, please. But nonetheless, I do hope this information helps you. I hope all the information I put up helps somebody. It's the sole reason I put it up there. And I wish you the best of luck.